Welcome to Hybiz News. My name is Suresh Kochatan. Tech giants Google and Oracle are clashing in the Supreme Court in the US in a copyright dispute that is worth more than billions and important to the future of software development. The case before justices on Wednesday had to do with Google's creation of Android operating system, now used on a vast majority of the smartphones worldwide. Google says that to create Android, which was released in 2007, it wrote millions of lines of new computer code. But it also used 11,330 lines of code, an organization that's a part of the Oracle's Java platform. Google has defended its actions, saying that what it did is long settled common practice in the industry, practice that has been good for technical progress. But Oracle says Google committed an aggressive act of plagiarism and sued, seeking more than $8 billion. Google is challenging an appeals court ruling that it violated Oracle's copyright when it included some Oracle-owned Java programming code in the Android phone. Sun Microsystems had developed the Java language before Oracle bought the company in 2010. At stake in the case are pre-written directions known as application programming interfaces, or APIs, which allow different software programs to communicate with each other, a function commonly known as interoperability. By using these shortcuts, programmers don't have to write code from scratch for every function in their software or change it for every type of device. Oracle says that the Java APIs are available for those who want to build applications that run on computers and mobile devices. But because the Java APIs are copyrighted, Oracle claims a license is required to use the shortcuts for a competing platform or to embed them in electronic devices. Google argues that the software interfaces weren't eligible for copyright protection. The company also says that even if the APIs are copyrightable, the Google's use of them would qualify as a fair use exception. The case has been going on for a decade. Google won the first round when a trial court rejected Oracle's copyright claim, but that ruling was overturned on appeal. A jury then sided with Google, calling it the copying fair use, but an appeal court later disagreed. Because of death of Justice Ruth Bader Ginsburg, only 8 judges are hearing the case, and they're doing it by phone because of the coronavirus pandemic. The questions for the court are whether the 1976 Copyright Act that protects what Google has copied, and even if it does, whether Google did, is still permitted. Oracle, for its part, says the case is simple. But the finale of the high-stakes litigation, which has been grinding through federal courts for a decade, may be remembered for another reason, as a case study of the subtle art of influencing the judges of the Supreme Court. The bare-knuckle Google versus Oracle brawl features a dozen of outside groups that have written, signed, or recruited others to join the friend of the court, or what is called the amicus curiae briefs. Many have received funding from one of these 2 companies involved, and for reasons unrelated to the case, but didn't disclose it, which is unethical. It's unheard for a company to outright lobby in the Supreme Court. Yet legal experts say that amicus briefs, which are supposed to provide independent perspectives from third parties, can influence the final outcome. The 60 friend of the court briefs for Google versus Oracle is 4 times the number filed in the average high court case. Among the combatants are a Hollywood lobby shop, a dark money group, an anti-big tech agenda, and an advocacy organization for blind people. Look at the case. The case pits tech companies that want freer use of programming languages against entertainment and media businesses that favor stronger copyright protection.